Okay, so as we know, we will start with Professor Fausto Pocar. He is Professor Emeritus of International Law at the University of Milan and the Honorary President of the International Institute of Humanitarian Law in Sanremo. He was Judge and President at the ICTY and also member of the Appeal Chamber of the ICTR. Professor Pocar was also appointed Judge ad hoc of the International Court of Justice in the case between Ukraine and the Russian Federation. So, Professor, military necessity has always been a sensitive issue and a notion used by the parties to the armed conflict to justify any kind of damage to the cultural heritage. How has this notion changed over time? Please, you have the floor.
Thank you for your question, and I wish to say my thanks to you and all the organizers of this seminar and the present roundtable that we are discussing now. Military necessity, let me say, has always been a basic rule in international humanitarian law. In a way, it's the basic rules on which all the principles of humanitarian law are related. Because what military necessity means is that in a conflict, when military operations are conducted, there should never be action that is not necessary. I mean, all military action should be conducted for the necessity of the conflict, of the conduct of the hostilities, but should not go beyond that. And that's why the basic principles of international humanitarian law, which are the principle of distinction, whereby one should distinguish between civilians and military, civilians objects and military objects. The principle of proportionality, whether no attack is legitimate if it implies a damage which is unnecessary, which is, let's say, it is excessive as compared with the anticipated military advantage. And the principle of precaution, in which those who conduct military operations should be taken all the precautions necessary not to increase the damage, are related exactly to necessity. Necessity means that any action must be necessary. Of course, these principles are in practice being frequently abused by the military, sometimes by both parties, by the defense, the party defending, which uses the cultural sites, the cultural buildings, cultural structures to protect itself. Say this will not be attacked, so I put my headquarters there. And on the other hand, you have the attackers that should be sure to attack only when the site is not civilian, is not considered a civilian object, so not used for civilian objects. And of course, the cultural heritage sites are essentially civilian sites, are not made for combat. So at the end, there is a clear abuse when they are attacked, because normally at least, it's not necessary to attack them, except when the party, the belligerent defending, uses them for military purposes. Take a school and you put a quarter in a school, saying the school will not be attacked, or in a hospital. But in that case, of course, the civilian object becomes military at the same time. At least there is a dual use of the object, and in this case, the attacker can attack in principle. for say cultural sites, the question is a bit different also, because there is the Convention of 1954 of cultural objects, which puts special rules in this respect. And it provides that one can attack a cultural object only when it is imposed by imperative military necessity. However, the notion of imperative military necessity is not clear in itself, and there may be a situation in which the abuse is self-evident. I think I exhausted my 5 minutes, so I can't go beyond that. Otherwise, I will. You tell me. I'm under your guidance.
Yeah, you can speak for other more.
Just to finish, then the question of the interpretation of the 1954 convention. The 1954 convention says that there is a general rule not to attack, not to expose the both sides the cultural objects to attack, to military operations. This rule may be waived by the parties, may be waived when, for the attacker, it is the other party that has already made use of the cultural sites on one side, on one hand, and may be waived when there is this imperative military necessity. What does mean imperative military necessity? Necessity is obviously imperative because the word itself says it's imperative. So adding the adjective in qualification imperative means it should be something else. Should be something else. How to interpret that? My interpretation, but it's not the common interpretation of everybody, but it's still the interpretation of the second optional protocol to the Convention of 54, is that you can waive the rule that imposes not to attack cultural objects when there is no other way of achieving the result of the military operation. If there is an alternative way, you should go for the alternative way. But the protocol is not general law. Has been accepted by some states, but not by all states. So that's the real problem. I mean, in my view, this interpretation of the protocol is just a clarification of the convention, and nothing more than a clarification of the convention. But the convention in itself can be interpreted only in this way, because what could imperative add if the notion that there is no other choice?
Thank you for your intervention, Professor. Now I'm gonna leave the floor to Professor Ahmed Aubais Al-Fatlawi. He has a PhD in public law, and he is full professor of public international law in the Faculty of Law at University of Kufa in Iraq. He is also member of the Permanent National Committee for International Humanitarian Law, the subcommittee formed by the Prime Minister's Office in Iraq. So, Professor, did legal philosophy debate the protection of cultural property even before the codification of the international humanitarian law? Yeah.
Good evening, good morning. Thank you very much, Hani. Thank you very much, Gianluigi. I'm honored to engage with the excellent seminar. To answer on this question, I will try to examine the philosophy rules to reach at a decisive criterion in determining the effectiveness of the IHL rules of protection versus the gravity of the violation according to international criminal law. Historically, the issue of cultural heritage protection witnessed dramatic developments which started with its approval within the ethics of war, then moved to the level of consumer regulation, and finally codified as in the framework of the topic. It's important to show of cultural heritage within the framework of the humanitarian effort to establish protective rules, the framework as well as restricted violation manner. In short, it is a taste of the general trend in determining the weight of cultural heritage at the IHL level, the relative gravity of the most dangerous behaviors, and its impact on attributing individual crime responsibility. The rules are in both national and international law focus word. As for the place of cultural heritage in the legal effort, we must answer the following question: what is the importance of protection in times of armed conflict if the cultural heritage does not directly affect the existence of human beings themselves or any civilian objects, like Professor Ahmed mentioned, that provide them with the means to sustain life materially. By review of the negotiations before the adoption of many international instruments related to the protection of cultural heritage sites, we will find that they focus on preventing the targeting of the value of what those sites contains, and not related to protect specific victims. In other words, if the philosophy of protecting the victims of armed conflicts relates directly to individuals, which is not crossing the acceptable borders of hostilities, targeting cultural heritage would mean crossing three borders. First, targeting cultural heritage sites in a community may cause reflections, including widening the scope of targeting heritage sites to other parties, while the second is embodied by causing unjustified and unacceptable suffering to those, victims, who believes that targeting their cultural heritage sites will embody a violation of high mental value and unjustified pain. And finally, the third and most dangerous border, when targeting an archaeological and natural site at the same time, as it would mean exceeding the limits of suffering by causing destruction in the natural environment. In all cases, the degree of philosophy of protection will increase compared to other violations, and this is what motivates the international community to adopt rules for the protection of cultural heritage sites within IHL. From the foregoing, it's clear that IHL rules has dealt with the issue of cultural heritage sites protection in a gradual manner. In other words, moving from mere general text to other more strict and clear. And the philosophy of this law was and still is based mainly on preventive measure. However, criticism may be directed at the lack of clarity on the dimensions of the principle of military necessity, like what Professor Ahmed mentioned, and visible precautions. And here it is necessary to reformulate the provisions in a way that narrows the resort to the targeting of cultural heritage sites according to military necessity, as well as emphasizing on the principle of due diligence with the framework of visible precautions.
Thank you so much for your intervention, Professor Al-Fatlawi. Now, I would like to give the floor to Stefano Crescenzi, who is an Italian diplomat, first secretary to the permanent Italian mission to the UN in Geneva in the Humanitarian Migration Affairs Office. He's also an expert in Maghreb, North Africa, multilateral Mediterranean, and protection of religious freedom. So, Stefano, can I ask you, what are the particular features of the protection of cultural and natural heritage in Syria, and what does this case study show testify? You have the floor.
Thank you very much, Hani. Good morning, good evening, everybody, to all of you in Canada and to my fellow panelists spread all around the world. And yeah, building on what has said before me, I think that the Syrian case it's quite peculiar and very interesting. First of all, because Syria is hosting 6 World Heritage listed sites by UNESCO, and because of its rich cultural heritage as well. In addition, Syria is part of the main conventions that has already been mentioned, beside the second optional protocol of the 1954 convention, a UNESCO convention, and then the ICC. And I will explain why also the ICC is relevant in this case. And Syria had a very developed domestic law in terms of cultural protection. The armed conflict that broke in 2011, that of course has been qualified as a non-international armed conflict, had seen different actors and different warring parties. And of course, IHL fully applies to all of them. But we have seen also targeting of the cultural heritage, intentional and unintentional, but mostly intentional, I would say, especially in a certain phase of the armed conflict. And it is relevant to the Syrian case also because we have state responsibilities, we have armed non-state groups that are fighting, and then they're deliberately targeting the cultural properties, and we have other actors that I will not focus too much, otherwise it will be too long. In this framework, I mean, against this backdrop, of course, we also have seen some of the non-armed, for instance, non-armed groups that also took a protective approach. So it's not always destruction. So this is very interesting, but mainly what we have seen and registered as international community was the attacks on cultural heritage. And even the government itself used, for instance, in Aleppo, some of the protected cultural sites as military bases and as a first line of defense. So this is clearly to connect it to what Professor Pokar was saying before. I mean, regarding military necessity, it is something that probably was not that, I mean, it is easy to establish that there was other options probably instead of using cultural sites. But despite, I mean, this legal framework, both domestic and international, and what could, I mean, all parties, of course, they were all called to comply to IHL. We have seen different violations of IHL rules. And even though it is somehow easier to identify those kind of violations, especially for some targeted attacks that has been recorded. We'll mention Palmyra site, archaeological site for all as one of the clearest example of this. But of course, we have also to understand which were the consequences of these violations. And here, of course, more problems will come because there were no prosecution in terms of domestically, and then of course there were no. Unfortunately, there were no follow-up on international prosecution for the perpetrators of these crimes, despite even the UN Security Council recognized the need for it. And of course, it is interesting because we have a set of rules, we have a set of international and domestic rules. We know who are the perpetrators, but probably the overall legal framework is not enough, neither to protect cultural heritage and also natural heritage sites during armed conflicts, and to deter it. So as a matter of deterrence of these kind of attacks. So also this is somehow questionable on what will be the role of the international community in fighting impunity, but also in respecting and act to respect and to make respect IHL, especially for protecting cultural heritage and natural heritage as well. Because as Professor Al-Fatlawi clearly already stated and mentioned, this is cultural sites, they have a value for humanity, not only for the population, for the local population. So I think this is this merits an enhanced and special protection as the 1954 Convention and the protocols already stated, but we have to do more collectively in terms of protection of these special civilian objects that are cultural and natural heritage. Thank you.
Thank you so much, Stefano, for your intervention. Something that of which I'm very touched. So now I give the floor to Christy Edwards, Professor Christy Edwards, that is head of the Policy Program and Legal Unit at Geneva Call. She also represents the organization on this discussion. She's an internationally recognized legal expert with over 20 years of experience working on international humanitarian and human rights law, gender, international policy and advocacy, and international community development. So, Professor, can I ask you if there are different trends between armed groups and de facto authorities towards cultural and natural sites? You have the floor.
Thanks. And I guess I want to say first, thanks for inviting me to join the panel as the one female representative on the panel. And given how many wonderful scholars and legal experts there are on this topic, I hope that many of these women will be able to join this conversation in the future. For those of you who aren't familiar with Geneva Call, I'll just quickly explain. Geneva Call works with armed groups and de facto authorities, or as we refer to them, AGDAs, to train them on humanitarian norms and principles, including the respect of cultural heritage and natural sites during armed conflicts. And we work with these groups to encourage them to commit to respecting humanitarian principles, as well as to institute accountability measurements for their commitments. And so despite deliberate attacks against cultural heritage sites, such as the destruction of 14 mausoleums conducted by radical Islamist groups in Mali, or the various actions committed by the Islamic State group in Iraq and Syria over recent years, I would say that AGDAs can't be considered as a monolithic entity with similar attitudes towards cultural heritage. And so we would define these into two different approaches. We would say one is the destructive trend, where AGDAs engage in deliberate attacks against cultural heritage as a policy or as a method of warfare, as well as the non-destructive trend, where they do not seek to intentionally destroy cultural heritage, and they may recognize the importance of ensuring its protection, even though their military tactics and or ignorance of international humanitarian law might still expose it to incidental or collateral damage. And so Geneva Call did a recent study on AGDAs and cultural heritage, which identified several firsthand accounts of both negative and positive practices in Iraq, Mali, and Syria, where some of these groups have destroyed or looted cultural sites and objects, including World Heritage sites, and yet others have taken concrete steps to respect and to safeguard them. And some of these safeguarding measures include establishing special departments of antiquities, adopting legislation or other regulations that prohibit the excavation of archaeological sites, the destruction and damage or trafficking of antiquities, posting guards to protect archaeological sites and religious temples, storing cultural artifacts such as ancient manuscripts or statues, which have been seized from traffickers in safe places, and also securing cultural sites with sandbags or other in situ means of risk mitigation. And so while some of the AGDAs might be reviewed as reluctant to accept the legitimacy of international rules, since they obviously are not signatories to any of these international conventions, and excluded from the norm-making processes and obviously are not parties to them, all of the organizations or groups that we interviewed expressed disagreement with the rules none of these groups expressed disagreement with the overall rules protecting cultural heritage. And on the contrary, actually, they all acknowledge the value of cultural heritage and recognize the need for its protection. And this view is particularly strong, I would say, against or amongst AGDAs that fight or claim to fight for the rights of national, ethnic, or religious minorities. And finally, I would say some groups, such as some of the groups that we worked with in Myanmar, see the protection of cultural property or the natural environment as an obligation to protect something that is external to them or their culture or community. And so these objects and places or flora and fauna are often very much a part of their community identity and or religious practices. And so they have a very strong vested interest in the protection of their heritage and identity, much in the same way that many indigenous communities view the environment as well and the need for its protection. So maybe I'll stop there and we can continue just definitely discussing this more in the future.
Yeah, thank you for your intervention. Now I will leave the floor to Professor Alejandro Lorite Escorihuela. He is a visiting professor in the Department of Legal Sciences at UCAM and has previously been a professor of international law at the American University in Cairo, in Egypt, Tufts University and Brandeis University in the United States, the Institut d'études politiques, Sciences Po in Paris, and the University du Québec, Montréal. So, please, Professor, I have a question regarding which is the relationship between humanitarian and environmental law? You have the floor.
Thank you very much. Can you hear me? That's okay. Yeah. So thank you very much to the organizers first for inviting me to join the panel and to my co-panelists. So to answer the question, I thought I would go and try to discuss the operational ramifications of rather abstract problems, I think. So abstractly and theoretically, the relationship between international environmental law and international humanitarian law is one of usually it's called an issue of fragmentation. So the idea is the international legal system is fragmented, divided into legal regimes. And so when there is a relationship between two regimes, we try to see how to solve the conflict. This has been popularized by the UN International Commission. It's been used by the International Court of Justice and so on. But basically, in terms of a solution, as we've been told, when there's a conflict between international humanitarian law or rules of international humanitarian law and other rules, international humanitarian law prevails. So what it means is that basically, as we've seen in the application of conflicting rules, when we say that IHL prevails, it means that overall the logic of war, the way it's described in the St. Petersburg Declaration of 1868, that logic prevails and engulfs everything. It means that, as we've heard at the beginning, the war is seen, legally speaking, as a regime of balancing interests where military necessity is a constant. So when I say that the logic of war engulfs everything, including the environment, it means at least three things. So the first one is the environment is protected only against extensive damage. So as the text say, it has to be widespread, long-lasting, and severe. The other type of damage is not as such considered by law. It can be debated, but that's what the texts say. Extensive damage, that is, so even if the damage is extensive, widespread, and severe and long-lasting, if it's justified by military necessity, it's not criminalized. And the third way in which the logic of war engulfs everything is that, as we've seen in current work on the crime of ecocide, a proposal to basically amend or revise the International Criminal Court statute to add a new crime of ecocide, extensive damage that is allowed in times of war is not allowed in times of peace. So basically, in times of war, there's a kind of damage that can be done that cannot be done in times of peace. Why? Because in times of war, there's a justification. So the justification that we've heard about at the beginning justification of military necessity allows for the type of damage that is not allowed in times of peace. So now to go back to the mention that has been made at the beginning of, so environmental questions, environmental problems today refer also to the protection of biodiversity and climate change. So transversal, global, structural problems, not punctual problems of protection of natural sites, but systemic problems. So in the conflict between IHL environmental law, we can see a difference or a tension that is caused by a difference in scale of the problems. IHL, the rules of IHL, they govern essentially tactical problems, not strategic questions. So strategic questions are left to the jus ad bellum, so the rules regulating the reasons why we go to war. But IHL as a regime, for the most part, in its operations, regulates tactical problems. And so tactical questions are questions of the short towards medium term, but not long term. So the question is, how does IHL absorb perspectives that come from an international environmental law, and particularly issues that have a connection with the protection of biodiversity or climate change? These problems, they transcend both temporally and spatially the space of armed conflict. And so it transcends, obviously, generations, because as we know from international environmental law instruments, we try to protect the environment for future generations, and also transcends frontiers. As we know, the environmental issues don't respect borders. So the question here is that because we know, legally speaking, in terms of legal reasoning and applying the norms, environmental law still applies in times of war. It doesn't, the fact that humanitarian law prevails doesn't mean that environmental law is thrown out the window. It's still there, and according to the International Commission and common sense, let's say, environmental law is supposed to influence or can influence the norms of humanitarian law and can influence the application of humanitarian law. So what does that mean? So if we imagine what it should mean the implications of considering environmental questions related to systemic problems in the framework of international humanitarian law, it means that military commanders should take into consideration issues that calculations of risk that come from environmental law. So from the perspective of the precaution principle or something like that, which means military commanders should have a perspective that is informed by the science of environmental science. And so immediately we can imagine or think that that's not appropriate, that it's doubtful that that's ever going to happen, or it could happen, or it even should happen. Should commanders be in charge of evaluating the risk, environmental risk of operations in that sense? In the sense of long term, it's not quite clear. And now we would think also it's not military commanders, it's also artificial intelligence that is there to support commanders. So to conclude, I'd say in terms of this is for now just a diagnosis, and then we can talk about solutions, but the relationship between environmental protection and IHL, now it seems it's situated at a breaking point of international law because of the conflict of perspectives. We can certainly think of the importance of environmental protection in practical terms, so particular discrete objects that can be protected and how to protect them. But the question is, how do we imagine the relationship between the operational workings of IHL on the field and systemic problems? So I'll stop by there.
Thank you very much. So to everyone. So I would go forward and do the second round, starting again with Professor Foucault, and I would ask him if, according to you, we can speak today about an excessive use of the principle of military necessity during war.
Thank you, Gianluigi, for this question. Before answering it, may I add one word on the last intervention of Alejandro, because that was very interesting, and I fully agree with him that environmental law, as other fields of law, continue to apply during a conflict. And the principal one has been the example of human rights law, which even the International Court of Justice have said that human rights law continue to apply and in a way influence international humanitarian law with the well-known principle of humanity that should also be applied, although it's not well circumscribed in the international humanitarian law. There just was an additional comment I wanted to make to strengthen the reasoning of on the question of excessive use of military necessity. I would say more excessive is normally abusive, is a misinterpretation of the principles. I will just give an example which is clear, an example of cultural heritage. The example is a bridge. The bridge of Mostar in Bosnia is a bridge in a town divided by a small river, but profound river. And this bridge is linking the two communities of that town. One is Croatian, so Catholic. The other is a community of Bosnia, Islamic, Muslim. So there are two different communities. They are linked by this bridge, and they always, the contacts passed through that bridge. And the community lived for centuries in peace with, so it's part of the culture to keep this. What happens? There is an attack, and the Croatian army destroys the bridge. Now, the bridge itself may be a cultural object, artistic object, but that was not the main point. The main point is that destroying the bridge will mean destroying the contacts between the two communities, also ideally, and say, well, you should not communicate anymore, you stay the other side and we stay here. This is the point, I mean, of the actual military operation. Was that necessary? The trial chamber, the case was discussed in the ICTY, the trial chamber convicted considered the operation illegal, the destruction of the bridge. When it was the appeal chamber to deal that, they applied the principle of military necessity. In this way, on the bridge, there was passage of civilians, but also of weapons. Light weapons in reality, because the bridge is curved and it's not possible to go with heavy weapons. But if you pass with a gun, you can pass with a gun, of course, the gun is a weapon. So on that basis, the decision was made by the appeal chamber to consider that the object bridge being used also for military activities, so passage of weapons, becomes a military object and therefore can be destroyed simply. So the necessity was not even looked at, was just, it's an operation that can be done because it's a rule that when an object is used for military purposes, it becomes a military object, so can be destroyed. So this was the decision that was made without taking into consideration the cultural aspect of it. The question that it was, maybe there was a use also for passing some guns from one side to the other, but in fact, this was not essential and there was no imperative reason to destroy them. So the military necessity should have been waived on that occasion, and using also the principle of proportionality and so on. But the appeal chamber went, in my view, the wrong way. I say that because I dissented from the majority of the chamber simply. And my reasoning was exactly the reasoning that international humanitarian law would not allow such an excessive use of military necessity. I wanted to give an example because that was exactly the cultural aspect of the bridge that's more important. The bridge you can reconstruct, and it has been reconstructed, of course, in part with the same stones because they had fallen into the river and they were used again for building the bridge. That's not a big issue per se, but the cultural aspect of that bridge was extremely important. Thank you.
Thank you very much. So the other question to Professor Ahmed Al-Fatlawi is if we can say that in the debate related to philosophy on cultural heritage has changed after the codification of this matter.
Thank you very much. It's important to say that IHL will not be effective in protecting cultural heritage without criminal rules defining the most serious of crimes, the status of many of criminal tribunals, whether the ICTY, ICTR, and finally the ICC, played a role in drafting the most severe crimes related to cultural heritage. But on what basis were the provisions adopted? Does this reflect the remedy measure of international criminal law? It's important to say that the first paragraph, the preamble of the ICC, referred to the cultures of peoples, which confirms the weight of these cultures and the necessity of protecting it. In general, at the level of the statute of ICC, we find it more explicitly in the statement of the relative gravity in article, for example, in Article 1, an international criminal court is hereby established and the court shall be a permanent body with the authority to exercise its jurisdiction over a person's relation to the most severe crimes. And also in addition to paragraph 1 of Article 5 and same statute, the court's jurisdiction is limited to the most serious crimes of concern to the international community as a whole, and the court under this statute has jurisdiction to consider the following crimes, and it's mentioned the 4 crimes. Also, Article 17 and 53 of ICC also statute refer to the gravity, relative gravity. It's correct to say that this is that the specific gravity is closely related to the subjective aspect of dangerous behavior, as the more it violates a higher value that is preserved in accordance with the law. The heavier it will be to come down in the field of codification and accountability. A related context, the destruction or disruption of cultural heritage committed during armed conflicts in itself embodies a qualitative weight for several reasons, including the horror of the committed act and the psychological and material suffering accompanying the victim, in addition to violating a rule embodying a high value that obliges the parties to the conflict to comply. The type of prohibited behavior would be even more weighty if it were committed against cultural heritage sites that are existentially connected to the natural environment. The review of the statute of the court, I mean ICC, we will find its emphasis on the remedial rule of any violations against cultural heritage. The first thing is to confirm the first paragraph of the preamble on the importance of the word heritage of peoples, and then set limits to the jurisdiction in the first paragraph of Article 5 with the phrase the most serious crimes. Then move to paragraph D of Article 17 to specify the scope of initiating an investigation into the alleged crime. Of course, all of this a crucial measure in determining jurisdiction and admissibility. The issue that must be considered is that the provision for tracking individual criminal responsibility may depend on qualitative and quantitative criteria. As for the qualitative aspect, it was necessary to determine the type of prohibited behavior that was punishable. the destruction of cultural heritage site is the most dangerous qualitative behavior compared to looting the contents of that site. At least this content will still exist and measures can be taken to restore them as opposite to destruction, which would end the physical existence of that site. The foregoing depends on the scope of crime, widespread, mentioned in paragraph 4 of article, for example, paragraph 4 of article 8 of the statute, as well as its severity on the victims. Although the statute of the court has focused on the remedial aspect, but it's also important to focus on the preventive aspects by drafting a text that triggers individual criminal responsibility against persons who contribute to the transfer of the contents of the looted cultural heritage, considering them as accomplices in the crime, as well as by amending Article 109 of the statute to add criminal measures against individuals responsible for international occasions that display the contents of heritage sites. On the other hand, if the rules of IHL have organized special protection of cultural heritage site, what is meant by those sites may raise legal problems. For example, the position of the sites that UNESCO has not classified as a cultural heritage, or sites that deny despised by the societies in which they are located. Therefore, defining the exact concept of sites will increase the effectiveness of IHL. In other words, there is link between the primary and secondary rules for the protection of these sites. Thank you.
Thank you very much. So the last question, the second question to Stefano would be about the destruction and damages of cultural heritage in Syria, has always caused more attention, more stir than the damages to natural heritage. So we would ask you if you can talk about also about the damages to natural heritage in Syria.
Yes, of course. Thank you, Gianluigi. Yeah, it is true that the cultural heritage destructions and damages and the looting of cultural property in Syria has attracted more attention. It is also because the domestic legislation was much more developed, for instance, compared to what was the situation in Syria in terms of protecting the natural environment. Despite the legal framework, of course, and given the civil character of the natural environment, with an increasing attacks and then the armored conflict that is lasting for now almost 12 years. We can see clearly some effects that are clearly impacting on the natural environment and the resources of the country, with medium and long-term effects, of course. Starting from the civil character, of course, I mean, this will pertain to the IHL rules that are governing the conduct of hostilities, as it has already been mentioned and perfectly explained by Professor Laurita. And of course, distinction, proportionality, precaution, we all agree on that. But during the armored attacks, clearly, and especially if from actors and belligerents that might not be well equipped in understanding also what would be the damages that they might provoke on the environment, as somehow scaled up the dimension of the damages that has been caused to Syria. In that regard, actually, one of the possibility that the IHL provides, and that has been further explored by the recent draft guidelines that has been adopted by the International Law Commission few weeks ago, that are clearly investigating and then drafting these main principles on the protection of a natural environment in the case of the armed conflicts. And it's interesting because they clearly states that something has to be done before, so in terms of prevention, and this is very important, especially from the state perspective, but many things could be done also during armed conflicts, and so in order to protect and then to avoid any indirect effects or losses of the ecosystem or incidental damages as well. I would just mention very briefly that one of the interesting tools that the International Commission identified was the use of special agreements, and in particular the demarcation of and the demilitarized zones. That there might be a very good solution. I believe that also what our colleagues from Geneva calls, and from her experience and what they are doing, it might be very an interesting tool also, especially with non-state actors. And clearly this is a kind of also overlapping, building on the positive experience of enhanced protection for cultural properties, then transferred and applied to environmental and natural heritage. So this might be something that hopefully in the future will be explored and developed, and that we should focus also attention on this. And I will stop to that. Thank you.
Thanks a lot, Stefano. So the second question to Christy would be, how can armed group and de facto authority be obliged to respect natural and cultural sites, and if they can be obliged or not?
Sure. Well, maybe I'll try to end things on a more positive note. Considering that the global situation with armed groups and de facto authorities, or AGDAs, are increasingly involved in major conflicts, and also including the destruction of cultural heritage. Some of the potential approaches could include encouraging state ratification of the 1954 Hague Convention and the 1999 Second Protocol. And some of the comments in amicus curiae briefs by UNICEF and others have encouraged developing cooperation with Geneva Call, which works to promote principles inspired by humanitarian law, along with armed non-state actors. And with this in mind, I think providing training to AGDAs on the international rules protecting cultural heritage in armed conflict is absolutely key. So I have a couple of examples from different contexts where Geneva Call has worked that I'd like to share to give some of the illustrations of how this could work in practice. In Syria, Geneva Call created some innovative dissemination tools such as videos or booklets, as well as a quiz application as part of its public awareness campaign, Fighter, Not Killer. And we've also developed a training module on IHL rules related to cultural heritage, specifically directed towards AGDAs. We've also piloted some training sessions conducted with the FSA brigade commanders on several occasions, and these were really well received and yielded some positive results on the ground. Following the training sessions, some of the FSA brigades reportedly took measures to protect cultural sites in Aleppo. In the DRC, multiple armed groups operate in North Kivu, including in the Virunga National Park, which is a UNESCO World Heritage Site. And the park has the greatest biodiversity of any park on the African continent, and it's home to many endemic or endangered species. And so the ongoing armed conflict there definitely threatens the national park. And some of the armed groups that are operating in the area often hide or operate in the park and rely on the illegal natural resource exploitation for the park, of the park for revenue, such as logging or fishing. Some of them also have family or social ties to the local population and use the anti-park sentiment for support. There are some tensions between the local population and park management over the regulation of the use of natural resources. grievances over land appropriation, and the exact boundaries of the park. And so within this context, Geneva Call has developed some awareness raising materials about the protection of the park or the environment as protected cultural property, using this broader notion of cultural property informed by cultural heritage law, and did some local awareness raising sessions with civil society organizations based in the area. And then in Mali, of course, many folks remember the deliberate destruction of cultural property in Mali during the conflict in 2012 and 13, such as in Timbuktu. But continuing to this day, cultural property remains to be threatened by the ongoing armed conflict, though it's obviously not in the news as much as before. So Geneva Call has continued to work on the protection of cultural property in Mali, in particular in the north, in the region of Mopti. And there you'll find the cliff of Bandiagra, the land of the Dogons, which is a paradigmatic example, I think, of the intrinsic links between nature, cultural identity, and cultural property. And the Dogon are an ancient people who live in harmony with nature, and nature is very much a part of their lives, beliefs, dance, and cultural rituals. And they rely on the cliff as a natural shelter, which is instrumental in maintaining their cultural identity. And the cliff is also a UNESCO World Heritage Site, both natural and cultural, and of course threatened by the armed conflict. So Geneva Call engages a variety of armed groups on the protection of cultural property, working with some of them towards making commitments in the form of a unilateral declaration. We've also been doing general awareness raising campaigns, such as radio spots or social media campaigns in French. We've run out of time, so I won't play that for you now, but just to say that we've been doing quite a bit of awareness raising in the area, both with civil society, the community at large, and with the armed groups in the area.
Thank you, thanks a lot. So the last question to Professor Lorite. What can be done, according to you, to improve the relationship between environmental and humanitarian law for the protection of natural sites?
Thank you so much. So just to continue the line that was following before, so the issue here is the relationship between the object of the different regimes, the two regimes at hand, and how we can harmonize them better. And the problem being always the same, which is there's tactical questions that have systemic implications now, and especially if we think of like concrete issues like the protection of biodiversity. So destruction of biodiversity can have systemic effects. Obviously, the most obvious examples is the use of nuclear weapons, that we've heard about again recently, but not only. So the question to go forward is how new environmental knowledge, or the knowledge coming from environmental science, can influence decisions that are taken within IHL. And this, I think, has to take into consideration the fact that both regimes, so international environmental law on one hand and international humanitarian law on the other hand, they ignore the necessity, or they're blind to certain necessities of the other regime. So war as such is not a specific or especially significant event for international environmental law, because that's not the focus. And it's been shown, for instance, that war is actually good for the environment in certain cases. So there's like famous examples where war obviously drives people away, and people are the main threat to wildlife in certain parts of the world. And so when humans are not there, well, wildlife thrives. So obviously this is, the perspective on, it's an extreme example of environmental law having a different perspective on war, obviously. So moving forward would mean importing into international humanitarian law the sort of universalist perspective of environmental law, particularly on systemic issues like climate change and biodiversity. And so the main implication would be to consider certain attacks on the environment to be completely off limits. So it's mean the environment would be off limits in the same way as murdering a prisoner of war is off limits. Like there's no excuse for it. That would be the idea. And so how do we do that? So following what Ms. Edwards was saying about the initiatives or the ideas that are pushed by the Geneva Accord, we can certainly sort of systematize the labeling of natural sites as cultural sites, like following the 1972 UNESCO Convention. So cultural sites and natural sites, they can be considered together, basically because cultural anthropology anyway has told us that culture and nature are the same thing. So that's one way of going about it. But obviously the problem with systemic challenges that are posed by, so the threats posed by war to systemic issues, and by war meaning also the preparation for war. The problem is that the site of the problem or the threat is not, easy to define, right? So if you start damaging air or water or things like this, it's not that you can locate the site of the damage. So that's a limitation to the labeling of the particular objects that should be protected as the environment. In terms of objects that need to be protected, like natural parks or reserves or certain discrete locations that can be labeled. So there's been discussions and hotly debated questions about how to protect them, and notably, so it was mentioned by Ms. Edwards, the idea of guarding putting guards in natural parks, that it's been done in several places, and that's debated because there's always a question. It's like arming humanitarian aid. So it's the same idea. If you introduce more weapons, is it a good idea? So it's a policy operational question, but it's a question. So there's also the international criminal law way. So I mentioned work on ecocide. So it's going in the direction of criminalizing sort of damage done to the environment, or criminalizing more damage done to the environment. The problem is, like, if we talk about systemic problems, there's no real ex post facto. So the international criminal law, like all criminal law, is an ex post facto intervention. So once the damage has been done, of course, we can talk about dissuasion or prevention effects of criminal law, but in terms of systemic impact, again, criminal law maybe is not it's one of the ways, but maybe not a way to privilege. Also, if we follow the logic of systemic problems, to call them that way, posed by war and certain tactical decisions that are made, so that have ramifications that we know from environmental science, or risk of ramifications that have been highlighted by environmental science. So if we follow that logic to the end, the idea of putting the environment off limits would mean that we take it out of the logic of IHL purely, and we move it into the domain of the jus ad bellum. So if the environment is common heritage, meaning that it's so precious, the environment, that if we damage it, we are risking the lives of humankind, then the object of the environment is taken out of the local to become a universal object, meaning that if there's an attack on the environment, or an attack that risks damaging in a systemic way the environment, such as it causes a threat to humankind, obviously the logic from the perspective of international law, it means that it becomes an object for the Security Council to take care of. So if there's an attack on the environment, it's an attack on not the enemy, but on the rest of the planet. So it's an issue for self-defense, Security Council measures, and so on. Obviously, it's not only sort of far-fetched, maybe, in a world of law dominated by sovereignty, but also it's a problem from the perspective of UNESCO, because UNESCO, as we know, has moved away from the universalism, so towards a more sort of locally sensitive approach. But that's if we follow the logic to the end. And obviously, the measures to better protect the environment based on the increasing amount of environmental science that we have would be a multi-layered sort of approach, right? And ultimately, I think the approach that is followed by Geneva Accord, so the revolutionary approach that has been to go and talk into the grassroots and talk about norms as part of military training. Well, the idea is that for future generations of combatants, integrating in their thinking the problem of risking systemic damage might be sort of the way to go, is to infiltrate the military training with that kind of thinking. So it becomes a sort of an unconscious reflex as part of how to wage war. That's it.
Thank you very much. So before concluding, I don't know if there are some questions, both online or in presence, and maybe Professor Ahmed Al-Fatlawi asked to add something.
Yeah, in the meanwhile, Professor Fatlawi.
Thank you, Hani.
Yeah, if you want to add something in 1 minute, we're going to ask if there's any question online and in presence. You have
Thank
the floor.
Thank you very much. I would like to clarify something. You know, the Iraq have tens of sites, I mean, cultural heritage sites, and most of it destroyed or looted, I mean, contains. For this reason, our committee, I mean, International IHL Committee in Iraq prepared a draft law, present maybe next month to Prime Minister office to regulate this issue, because Iraq ratified in Geneva Hague Convention and also the additional protocol of 1999. This is for clarify something about my country and its efforts to protecting heritage sites. Thank you.
Thank you very much. Actually, there is a question from the floor, please.
Hello, everyone. I'm Pierre, and I have a small question for Professor Pokar and also one for Christy. First, to Professor Pokar, I found the example you gave in Bosnia very enlightening to me. And just by interest, I wanted to know if you could explain very briefly a bit on the proportionality test that was made, because we had the explanation on necessity, but without knowing anything of the context, it seems to me maybe another measure would have been as effective. For instance, just controlling the people crossing, controlling if they had weapons, and this way, without exploding the bridge, people could still pass. So that's my first question. And then to Christy, I was wondering if you could explain a little bit on how the awareness program in the DRC, especially, how it is received, first of all, by the armed groups, how they react to this, but also by the local population. And also I was wondering if the government was helping you, was behind it, how they reacted to it.
May I answer or okay? The proportionality test, this simply was not done by the court, and the criticism was having omitted the proportionality test, because you create an excessive damage without calculating whether there is an anticipated advantage that is proportional to the damage. So which should have been done, actually. In fact, there was another bridge at 300 meters, 400 meters, half kilometer, which was a modern bridge, not cultural, and weapons could continue to pass that bridge. So they should have have destroyed that bridge. It was destroyed 3 days later, instead of attacking the cultural object first. And then there could have been other means, as they controlled one side of the bridge, they could stop the access to the bridge, simply. That was one of the, this has not been discussed in substance, but they should have tested if there was another measure possible to avoid that some guns passed through the bridge. Stopping the access to the bridge would have been sufficient for the military operation. It was not necessary to destroy the bridge, actually. But destroying the bridge was useful to give a message to the community, the other side, that they would stay the other side. And that was finished, this cultural contact with this part of the bridge. this was the idea, clearly. There was no other reason for destroying the bridge.
Okay, well, makes sense. Thank you very much.
I'll try to be quite brief in the interest of time. I would say, so the conversations we've had with all of the AGDAs that we've worked with, they've all been very supportive of protection of cultural property and the natural sites. Obviously, this is very much a part of their culture, their community, the environment in which they've grown up and live and have, you know, thousands of years of history in these areas. So generally the conversations are very, very positive. But I'm going to put in the chat the longer study. I didn't have time to go through 70 pages of our study today, but
Oh, we lost you.
You muted yourself.
Sorry, I'm muted. All right, so very quickly, just so I don't take more time. It's been a very positive set of conversations, both with the armed groups as well as the local community members, government authorities, because of course it's these areas are of significant importance to all of them. Now, the conversation about targeting and military necessity, those of course are those are challenging ones to have, but nevertheless, the general principle of protection has been quite well received. So I put our study with more information about this in the chat in case anybody wants to read more about it.
Cool, thank you very much.
There's a question maybe from the virtual room. I think is Camille Desmarais wants to speak.
Yes, thank you. Very quickly, I was wondering, for all panelists, do you think there should be a liability for a foreign belligerent when they intervene in conflicts? For instance, I'm thinking about the American inaction towards like the looting of the National Museum in Iraq, like during the Gulf War. I was wondering if the foreign belligerent would have a role to play.
May I ask for a clarification? Do you mean when you speak of foreign belligerent, you speak of interventions by states or entities that do not participate in the conflict, that are not party to the conflict, or what are you meaning exactly? Because
if like a state that decide to intervene in the conflict, like.
I mean, whoever intervenes in a military operation, irrespective of the title of its intervention, that destroys cultural objects, participates in a way not necessarily in the conflict as such, but it participates with military in a military operation. So, in my view, is liable, absolutely liable for the destruction. There is no doubt.
Maybe a little clarification. I mean, for instance, if a state intervene in a conflict, destabilize the state, what liability it should have towards if it witnessed, for instance, looting, would it have to intervene or like provide some assistance or guidance in that context specifically?
Well, it depends on the control they have, actually, on the control of the situation they have. But you were referring to Iraq, I think. And in Iraq, there was a military operation that was authorized by the Security Council. So we have to take that into account. But it's again a military operation. So as a military operation, has to respect international humanitarian law completely, strictly, in my view.
Okay. Thank you.
Okay, so are there any other questions? No. No. So I think we spoke about a very crucial point. For instance, the importance to respect some of the basic principles of IHL regarding also to cultural heritage, like precaution, proportionality. Also, I think it is very important to give a right interpretation to the principle of the military necessity. As Professor Pokar said, maybe the a good interpretation could be the one of the second protocol to the convention, but the second protocol is not universally ratified. So maybe what can be also important to go forward would be to raise awareness about the importance to sign and ratify the second additional protocol to the convention. Also, I think Syria, and I thanks again Stefano, is a very important example to see that both it is important to consider maybe together both natural and cultural sites. So and also to raise awareness towards armed non-state actor, de facto authorities like Geneva Call continues to do, achieving excellent results every day. So to conclude, I think that it is important to also to apply environmental law during armed conflict, and to understand, as Professor Ahmed Al-Fatlawi clearly explained very well, also the philosophical value of cultural and natural heritage that is related to all human beings. So maybe the most important, the most significant step to achieve further result would be to adopt a multi-level and comprehensive approach that puts together natural and cultural sites. But I thank everyone. I don't know if Annie would like to add some.
I think it's you said what I wanted to say. So thank you all. Thank you for this opportunity, this chance, and we'll be back in 10 minutes.